Hi, my name's Steven Goldstein. I'm a criminal lawyer in Mount Sinai, New Jersey and New York City. And today I want to talk about what happens in a criminal case for somebody who's been arrested for the first time. So this video is specifically if somebody has never been arrested before, someone has never been charged with a crime before, what's the process they can expect and what are the outcomes they can expect. So I'm going to talk to you today like I would talk to somebody who is coming to me for the first time. And over the course of my long career, as you might imagine, when I get a call from somebody who's been arrested for the first time, they're in a very emotional state. They're scared, nervous, anxious. They're never really happy making that phone call to me, and I'm quite aware of what they're going through. And what I tell everybody on their first phone call with me is what I'll tell you if you're watching the video and you are somebody you know, love, care about, has been arrested on a criminal charge for the first time in New Jersey. Most people are scared of going to jail. That is the first question that everybody asks. Am I going to jail? I can't go to jail. I'm scared of going to jail. Most, if not all, criminal cases for somebody who's been charged for the first time do not result in jail time. Most of the time, people are put in what we call diversionary program, meaning they do something for a year and a half, and the case gets dismissed. If they have to, because of circumstances, plead guilty to a crime. Most, if not all of the time, it's some sort of probationary period where you do not go to jail. In most cases, if someone has been arrested and spent any time in jail after the arrest, and we'll go through why that is, that's going to be the last time they're going to be going to jail on their case. As I'm talking to you about what you can expect on a case where you've been arrested for the first time in New Jersey on a criminal case, understand that the fear of going to jail really shouldn't be there. I can always talk to you and say, don't worry about it. You're going to be concerned. But having done this for 30 years, I can tell you very few people who are arrested for the first time for most any charges, even violent crime, do not go to jail. Let's first talk about the two different types of crimes in New Jersey. You have your disorderly persons offenses and you have your felonies. And disorderly persons offenses are what most people who are arrested for the first times are charged with. And those can include simple assault, shoplifting, minor theft, trespassing, harassment. Those cases, if you're charged, those wind up in the local municipal court of the town where this crime that's claimed to have happened took place. The other type of crime in New Jersey is more serious, and those are felonies. And felonies in New Jersey are graded from least serious to most serious: fourth degree, third degree, second degree, and first degree. Now, I told you that most of the people who are arrested for the first time do not go to jail. However, if you are arrested and charged with a first-degree crime, then unfortunately the odds are, short of an acquittal or a really good defense, there is a presumption of state prison time. And when I talk about first-degree cases, I'm talking about attempted murder, armed robbery where there's injuries. You're talking about really, really serious violent crimes. But for purposes of this video, we're going to talk about more of the usual felonies that people who've never been arrested are arrested for, and that might be shoplifting over a certain amount of money, theft over a certain amount of money, aggravated harassment, perhaps aggravated assault in the heat of passion, or maybe a bar fight. The most common, though, is usually possession of drugs, narcotics, not large amounts, but even possession with intent to sell. Those are generally the most prevalent types of felonies that people are charged with. I'm going to try and take you through the process of each so you can see how it all plays out and what you could expect if this is the first time you've been charged. So if you've been charged with a municipal offense or a disorderly persons offense, the odds are very high you will not be held in jail. You may be held at the local police station, and then you will be released. When we talk about felonies in a little bit, there are things called detention hearings where you may spend a couple of days in jail before you're released. But on the municipal level, what normally would happen is after you're released, you'll be released with a summons, and the summons will give you a date for you to go to court. And what should you do at that point? That's the best time to talk to a lawyer. I kind of recommend, if it's a municipal case, sometimes you may want to do a little research about the lawyer who maybe is appearing in that county or that town more often than not, because 99% of municipal court cases are worked out via a plea bargain, meaning you're charged with one thing and you plead guilty to a lesser offense. Now, if you're charged with a crime, a disorderly persons offense, the maximum that you could be sentenced to jail is 6 months. It's very rare. that somebody charged with a disorderly persons offense and actually convicted goes to jail. Usually the penalty for that would just be, if you're convicted of a disorderly persons crime, is probation. Sometimes not even probation. Sometimes it's just a simple fine and you walk away. Just to run through it somewhat quickly, what happens is after you retain the lawyer will send in a letter to the local court saying, I'm representing this person and please give me discovery. And discovery in municipal court could be voluminous depending on what type of case it is. But if it is initially brought in municipal court, you'll normally get a police report that will outline the police officer who arrested you or who responded to the scene, what they saw, what they believe happened. The lawyer may also get body cam video. There may be security video depending on what's charged, and the police may take statements from a victim or potential witnesses. Your lawyer will get that, and they will then go over it with you, and they'll discuss possible defenses to the particular crimes. In this video, I'm not going to go over the particular types of cases. This is really to just give you a general overview of the process you'll be facing in a municipal court case and in a felony case. So in a municipal court case, understand this too, in most, if not all towns, except say the bigger cities, say maybe like Newark or Patterson, the prosecutor is also a part-time employee. The prosecutor will have their own law job. They'll either have their own law practice that may not even involve doing criminal law. In a lot of towns, the local prosecutor could be a personal injury lawyer, a real estate lawyer, but 1 or 2 days a week, they act as the prosecutor for that particular town. And the reason that's important to understand is that unlike in a felony case, where those cases are handled by full-time prosecutors whose only job is to prosecute, it makes it very hard to kind of have your lawyer talk to the prosecutor before you literally are showing up to court on the day you're showing up. And sometimes as a client, you'll be nervous, understandably, and you may be calling your lawyer and saying, hey, what's going on? Have you spoken to the prosecutor? And a lot of prosecutors at the municipal level will get very annoyed when people call them because they're really not making money. It's not really their full-time job. So it's my practice normally to talk to the prosecutor the day of when we get to court, whether it's in person or on Zoom. Again, 9 out of 10 times, whatever your case is, it will resolve. It'll either resolve in a couple of different ways. So in municipal court, you have diversionary programs called either conditional discharges, which is if you're charged with very simple drug possession, or a conditional dismissal, which is if you're charged with another offense and the prosecutor thinks this is not really worthy of prosecuting, this person deserves a break. In either case, if you are given a conditional discharge or conditional dismissal, all that really means is stay out of trouble for 6 months to a year and the charges will be dismissed. The second way they get resolved is a prosecutor will say, you know what, let's work this out. I know your person has never had a criminal case before, they've never been convicted. I will offer them what's called an ordinance. Now, an ordinance is a law that's written by the local town. It's not written by the state legislature, so it's not a crime. Pleading guilty to an ordinance, in most cases, which would be disturbing the peace, does not carry with it the stigma of having a criminal conviction. What that does is, it's the equivalent, I tell people, of pleading guilty to a parking ticket. You plead guilty to an ordinance, you pay a fine, and you can get it expunged in a short amount of time. But if you're ever asked if you're guilty of a crime, you can answer no. The third way they resolve is you do take a plea to a disorderly persons offense. Again, 99 out of 100 times, it's probation or maybe not, and a fine. And the process could take about 2 or 3 court appearances, and usually the case is resolved that way. So that's kind of your journey, the short version of the journey of a municipal court case. Felony cases are obviously a lot more serious and a lot different. We'll kind of do it backwards. We'll talk about potential punishment first, because that's what really people care about most when they go and retain a lawyer. So in the Superior Court, when you're charged with a felony, if you're charged with a 3rd degree or 4th degree crime, and it's non-violent usually, but even on a violent crime, you are eligible for what's called pre-trial intervention. And pre-trial intervention is a program that's run by the county prosecutor's office. It's not run by the courts, where it's basically your get out of jail free card. So if you're charged with aggravated harassment, if you're charged with theft of over a certain amount of money, if you're charged with other felonies, maybe trying to elude the police, if the police are trying to stop you, a whole host. I mean, there's a lot of felony charges you could have. If you're charged with a 3rd or a 4th degree, one of 2 things could happen that get you out of the charge. One is the county prosecutor could look at your charges and say, you know what, they're charged with a 3rd degree, not really serious enough, we're gonna downgrade it and send it back to the municipal court, where you will go through the process that we just talked about. And those happen usually on simple drug possession charges. You're caught with one Xanax or a prescription pill that wasn't prescribed to you. And it's clear you're not a criminal. You just unfortunately got caught with something you shouldn't have had. But there's a lot of times, and I would say in my case, a lot of my cases, at least half, where the cases just simply get downgraded to the municipal court and you're not charged with a felony anymore. And the other way they could get resolved quickly is pretrial intervention, which, as I explained, is a program run by the prosecutor's office. And you apply, it's $75, and under the court rules and the statutes, there is a presumption that you will be admitted to a pretrial intervention. If you're charged with a third or a fourth degree crime, and it's your first offense, most of the time you will be able to escape without any criminal record, depending on the case, of course. If you're charged with a second degree crime, and it's your first offense, you are still eligible to apply for pretrial intervention, but your attorney has to get permission from the prosecutor's office to apply, and then they will have to submit what is called a statement of compelling reasons why the prosecutor should consider and put you into pretrial intervention when you're charged with a second degree crime. If you're charged with a first degree crime, you will really not be eligible for PTI or be accepted. So we did the last thing first, again, hopefully to put you at ease, to let you know that most, if not all of the times, even when charged with serious felonies, even second-degree felonies, it is possible and most likely that you will be avoiding jail time in a case like that, and in a lot of instances, having the cases downgraded or dismissed outright. Now, some of you watching this or just are curious, when you're arrested for a felony charge, a prosecutor has the right to say, you know what, we want this person held in jail until we can do what's called a detention hearing. And a detention hearing is where the prosecutor feels that either because of the nature of the crime, this person may be a risk of either not showing up to court or reoffending while they're out. Now, again, this is for first-time offenders. So most, if not all of the times, unfortunately, someone will spend 2 or 3 days in jail, but at the detention hearing, they will be released with conditions because since it's the first offense, their risk of not showing up can't be really judged because they've never been arrested before. And their risk of reoffending is usually low because it's their first offense. And they're released on things called either on their own recognizance, where you just get to leave, or with conditions, such as you must report to probation once a month, in person or on telephone. But most of the time you'll be released. And now your case starts. So assuming your case is not remanded down to the municipal court, what will happen is hopefully you'll retain a lawyer, and your lawyer will put in a piece of paper called a waiver of first appearance. Because once you're arrested, you will be given a date to appear in court, but that date is just for a judge to read the charges to you. If you retain a lawyer before that date, the lawyer will submit a piece of paper called a waiver of a first appearance, and you will be excused from court. The next thing that would happen is the lawyer would request discovery from the county prosecutor's office, and they will get it. And then they will be able to send it to you, and they will be able to talk to you about the potential defenses and about what the evidence is against you. The next step would be what's called a pre-indictment conference, and that is where the prosecutor tries to resolve the case before anybody has to start doing any real heavy lifting. And that is where you'll get the best deal that they will offer you. And that means usually either a downgrade of the severity of the charge, an offer to apply to PTI if it's a second degree charge, an offer to plead guilty to a felony with no jail time. But that is where you're going to get your best offer. Let's assume the offer is rejected and the case moves forward. You will then fill out a piece of paper, or they will then say, okay, we're going to send this to a grand jury. And the grand jury is where 23 people will hear the case, and they will determine if there's enough evidence against you to indict you, which is where the real criminal case now starts. It does not start on your arrest, it starts with the indictment. After the indictment, you will get a date for your arraignment. And the arraignment is where the judge will read the charges to you again, your lawyer will put in a plea of not guilty, and then a number of things will happen. The judge they may make another offer to you to resolve the case. They may not. Most likely, again, if it's your first offense, they will. And there will be motion schedules set. For instance, in a drug case, if there's a search issue, that will be decided when it's going to happen. Let's assume, we're not going to talk about trials, we're going to assume that there is a guilty plea, And now, because you've pled guilty, you'll have to go in front of a judge. You'll have to tell the judge what you did wrong. And that also would occur in the pre-indictment stage 2 if you're going to take a guilty plea to the pre-indictment. After pleading guilty, you will be sent to probation. They will do an interview with you, and they will prepare a report for the judge, at which time you will be given a sentencing date. And at the sentencing date is where a judge would say, here is what your sentence is. It's probation. Again, very, very rarely it's a jail sentence. Most of the time, these things are worked out between the prosecutor and the defense lawyer when they're doing the plea bargain. And again, because this video is really geared for people who've committed a first offense, it's somewhat rare that somebody's going to be sentenced to jail if they take a plea bargain. Again, we're not going to talk about someone who goes to trial on this video. It's not the purpose of this video. So that's kind of like the overview of what a criminal case will be like. Now, it's a short version, but there will be multiple court appearances. You will have to go a pre-indictment conference, arraignment. Every time there's a court appearance, you have to be there. The guilty plea at sentencing. It's a lot of time and expense to be charged with a felony and to go through it. However, the real point of this video, besides giving you an overview of the process, is to, again, put you at ease. A felony case is really stressful, and it could really affect your ability to be with your family, to do your job. It weighs heavily on people's minds. Again, when someone comes to me for the first time, I really do my best to make them feel at ease and say, look, I know you're charged with a felony. I know it's serious, but at the end of the day, you're going to be okay. And I think I could safely say this to most of you watching this. If you're the person who's been charged, at the end of the day, you're going to be okay. It may be a rough road, but a felony charge being handled by a competent and good criminal defense attorney should result at the end of the day where you're going to be okay, you're not going to go to jail, and hopefully it's not going to affect your job. We're not getting into the points of immigration on this video, but if someone is not in the country legally and they're charged with a felony, there's a lot of other issues that get called into play that we're not going to deal with on this video. So I hope this was informative, but most of all, again, I hope it puts people watching this at ease, that a felony charge is serious. It's not the end of the world. A municipal court or disorderly persons offense charge is also serious. It's a criminal charge, but certainly there are ways to deal with that it should not affect you. If you have been arrested and you know somebody who has been, or you're just looking for some questions answered, you could always call me. My office phone number is 973-912-0555. My website has a lot of useful information and videos on it, is www.ghlawnyj.com. If you want to email me, I'll be happy to answer a question. My email is steveng@ghlawnyj.com. So I hope you found this helpful. Most of all, I hope you found it reassuring that, listen, the law recognizes that people sometimes make mistakes. And believe it or not, a lot of times the law wants to help and not harm people or hurt people who've made that one mistake in their life. And again, after watching this, I just hope you don't ever have to get charged with a felony, but if you do, the odds are things are going to work out just fine for you at the end. Thanks.